Well, good morning, everyone. My name is Richard Ponte, and I'm the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of the entire team here, it is my pleasure to welcome you to Implications of Immigration Changes on Maine Employers, the latest in our webinar series. Thank you for joining. Before we get going, there are just a few things we'd like to share with you about today's session. All participants are in listen-only mode. Please submit questions using the Q&A function. Time permitting, we will answer them by the end of the session. We will also use the Q&A feature to share useful links and other materials. We have enabled closed captioning in English. You can access this feature by toggling it on the taskbar at the bottom of your screen. The meeting is being recorded, and we will make the recording available to you on our website in the next few days. And finally, if you lose your connection, please use the same Zoom link to reconnect. We would now like to begin by thanking our sponsors. Our premier sponsor is Native Maine Produce and Specialty Foods. Our senior sponsor is Pierce Atwood. And our 2025 webinar series sponsors are AARP, Bangor Savings Bank, Kennebec Savings Bank, MEMIC, Merrill's Investigations and Security, Northeast Delta Dental, and Summit Natural Gas of Maine. It is now my pleasure to introduce the President and CEO of the Maine State Chamber of Commerce, Patrick Woodcock. Patrick will be moderating the conversation today. Good morning, Patrick.
Well, good morning. Thank you all for joining us on this timely topic. The purpose of today's webinar is really to get beyond the headlines. There's been significant changes at the federal level that affects all employers in Maine, and regardless of the merits of the policy, we really do want to ensure that employers understand how to be in compliance, be aware of potential changes that may be coming, and overall have a discussion about the implications of potential ramifications on Maine's workforce. The Maine Chamber has long been supportive of creating an atmosphere of welcome and support and integrating immigrant communities that are authorized to work into our state's economy. I've been informed by employers that potential changes could affect a majority of employees. This could have significant ramifications for our state, in a state that we have fundamental concerns with our long-term demographic projections. We do want to get beyond the headlines. It's important that employers understand that there may be employees that were authorized to work that may be affected by changes and may not be authorized to work now or in the coming months. I really want to thank all of our presenters who are experts in their fields for joining us today in a way that we hope is informative and allows employers to understand the changes with federal immigration law and the implications for their workforce. To get started, I'm very pleased to have Tarlan Ahmadov, who is the new director of the Office of New Americans, provide a snapshot of Maine's immigrant communities and implications for where these populations are coming. Tarlan, I'll turn to you to give a primer on Maine's current immigrant community. Tarlan.
Hello, good morning, everyone. Thank you, Patrick, for inviting me. I appreciate, and it is really a great time to discuss this important topic. And I also greet my friends on this panel. So as Patrick said, I'm the new director of the Maine Office of New Americans. We just started about months ago. So here I would like to give the very high-level snapshot about what is immigration and what is immigrant are here in Maine. So can we just go to the next slide? So when we talk about immigrants, actually, if you look at that, it's like how many immigrants, and actually all this, our state and country is built on the immigrations and immigrants, right? So according to American Community Survey, which is the Census Bureau says in 2024, Maine has a total population, and first time for the long time, 1.4 million people. And it's about 53,000 and a little bit more are immigrants. So we're talking about 1,000 people, some variations. So what officials, 53,628 immigrants. which comprise about 3.8% of the whole population of the state. And surprisingly or not, actually the largest number of immigrants, we see about 18% from Canada. So then we see the 9% from Philippines and Germans, about 7%. Those people who put their, identify themselves in these census. So 90,000 are about 7% of the state population were native-born Americans who had at least one immigrant parent. So it's really important to know these numbers and the scope of immigrants here. So the next, if you don't mind. So the next slide is really interesting. Is also just shows about it's a more in 2024 that was also been from the census. It just shows about 19% from North America. So it's almost the same percentage what we see from the previous slides. So we have about 11% Latin Americans and from Asian community, people who born in Europe and also in Africa. So this is really interesting chart, and we see that later in other slides how this just shows in the whole immigration in the state. So the next slides. Next slides is all about those immigrants who entered from 2010 up to now, so about last 14 years. So if you look at that chart, so we see about from the overall, the immigrants community, we have increased arrivals of the immigrants from Africa. Same, we can see it was like before Asian community. So it's about from Africa, it was 38%, and which is comprised about 19.5% of all immigrants. So from Asian community, we see about 27%, and it's within 25% of overall immigrants. And then from the European countries, we see a lesser arrivals, or it was if compared to previously, but it's about 14.8% overall, which is for the last 14 years arrivals. And from Latin America, we see about 12.6%, which is within the 11% of the total immigrants. And then we see also from North America about 6.2%. So, and Oceania is very small percentage here. So can we just go to the next one? So the main population by age. We have here, as you know, we have about 44.8% our main population, like medium group age. And if you look at the native born and foreign born, so if you the native born is in blue color and orange color is foreign born, we see in the bracket of the 5 to 17 years, 18 to 24 years, 25 to 44 years, we have the high number of the foreign born, and then which is about 45% overall population within that foreign born. So they are very young, and they are part of our labors. So we see the kids within 5 to 17, they're always they are on the high level number. Same in the bracket between 16 to 24, and then labor. This is really a big number in 25 to 44 year. The age of the year. So the next one. I'm trying to go fast. Sorry. So the next one is just again shows to us so total population. The age medium age is 44.8 year. So the foreign born who entered between 2000 to 2009, so they are about 41.5. This is the age, medium age. And if you look at the latest arrival between 2000 to 2025, 2010 to 25, so the last 15 years, we see the median age is 30.7%, which is really important for us to understand, because within this discussion about the labor market and employment, so this is really important engine for our economy. We see this as a young population, eager to work and do the best. So the next one. In terms of education, so in this educational, you see there's two different kind of part. On your left side, we see it's a bachelor degree. Overall number of the bachelor degree in total for the state of Maine is about 21.9% of population has the bachelor degree. And those who foreign born, we see it's a 22.3% within this 21.9%. So it's a really big number. But the last one in the gray color, this is the showing for the last 15 years arrivals, and it's about 28.5%. So the last 15 years arrived immigrants are very, having like almost 30% are with a bachelor degree and higher. So on the right side, sorry, can you go backwards? On the right side, this is with the graduate degree and with professional degree. So like doctors, like those people who has a licensing and doing a lot in the labor. So we see over the same thing. So we have about 13.1% of total our population has a graduate or professional degree, and the latest arrivals in the gray colors also high compared to other columns. It's 21.7%. So the immigrants who came for the last 15 years, well educated, entering to our labor with good skills and education. Okay, the next one. So this one shows our, again, population with age 16 and plus. So we have about 62% in this bracket, and labor participation, which is closely related to age structure of our population. The age structure of this recently entered foreign-born population is much younger than both of these other two categories. So if you just compare, so the 70.7%, those foreign-born who just came within last 15 years. So do I have more time, or shall we just go to the Susan, or?
Maybe a couple more minutes, Tarlan. Thank you.
So the next slides, actually, if you go, is just, we'll be talking about, definition of immigrants. So if we talk about immigrants, it's really, we have to look at those people who is the green card holders, the spouse of US, or people who just win diversity lottery, refugees and asylees, temporary protected status holders, and many different, students and visit. It's a really large definition for immigrants. And I think it's sometimes we're just only looking for the very small fracture in this population, but we have to look at this as like in a big picture. So immigrants are playing a very important role. And the last slides actually talks about how it's important. So President Kennedy, if you go to the almost last slide, tells about very inspirational words. So every aspect of American economy has profited from the contribution of immigrants. I think it's really important to us understand how the President John Kennedy inspiring us to look to this important subject. So I myself, immigrant here for 22 years, and I'm very honestly happy to be in this beautiful state. Me and my wife work, and my children working here in full capacity. We're doing all the best, and we are very appreciative to all Mainers to welcome us here. And we committed to be here and being the citizens and contribute back to our beautiful state of Maine. Thank you again.
Well, thank you, Tarlan. That was a great primer on and challenges, perhaps assumptions about our immigrant population in Maine. I will say you touched on this, that there are a lot of complexities with immigration status and different authorizations. The purpose of this webinar is that we really can't make everybody an expert, but there is a lot of best practices as an employer. And we're very pleased to have Katie Minervino, who is the chair of the immigration practice group at Pierce Atwood, to really inform employers of what they should be going through right now with so much changes occurring at the federal level. Thank you so much, Katie, for joining us.
Thank you, Patrick, and thank you, Tarlan. I think, just to kick this off, there's a lot going on for immigration, and Sue's gonna walk you through some of the developments. But one thing I thought was interesting from the early slides is the figure of 3.8% of our population being immigrants. That's relatively low, but it's very important for everybody in this presentation, all employers, to understand that 100% of employers have an obligation to support the immigration system. So immigration applies to everyone, and the primary role that employers play, especially at the point of hire, is completion of the Form I-9. So the Form I-9 is required for all employers, and this has been the case since 1986. So we're, kind of like in our 40s as the Form I-9. It's been around for a while, but it's a kind of a form that came out of the Immigration Reform and Control Act, where the federal government, when they passed the law, decided to essentially deputize employers to help verify and vet the employment authorization for the U.S. workforce. So it is essentially a primary tool in our immigration system for verifying that the individuals who are in the United States are working lawfully. And this applies to all workers. So you may say, I'm a small family business and I was present at the birth for my kids. And I know that they're US citizens. Do I still need to do the Form I-9? And the answer is yes. So the Form I-9 applies to all new hires, whether you're a citizen, a lawful permanent resident, or other U.S. worker, or you have temporary work authorization, and it needs to be completed at the point that the hire takes place. And there's two main components to the Form I-9. One is the paperwork piece of it. Did the employer complete the form? Did they do it correctly? Are there errors on the form? What does that look like? Did you do it? Did you retain it? There's a paperwork component to it. There's another piece of it also that is the knowingly hiring unauthorized worker piece of it. So if you are doing the form and the form is completed and the information presented reasonably appears to be genuine, relate to the worker, you will not be liable if any of your workforce is unauthorized because you've done the form and you've checked. If you don't do the form or that somebody's not work authorized, there's a separate civil penalty component to having people work for you without authorization. So the Form I-9, it can feel like it's an administrative burden at the point of hire. Everybody's busy, HR is doing a million things, but it really is a tool, in addition to the form, for the government to confirm that the workforce is authorized. And it's also a tool for the employer to make sure that they're doing their due diligence and, kind of insulating themselves from liability relating to who's working for them and what their authorization is. And the stakes are relatively high, with the I-9. The paperwork penalties are going to be assessed if you were to have an inspection and a assessment as of the date that the inspection issue is noticed. So there's a civil penalty inflation act that goes into effect. So, kind of as time goes on, even if this error occurred a long time ago, you're assessed in real time. And right now, the current penalties per form will range from $288 to $2,861. So there's, kind of real money involved, in the form if your paperwork's wrong. If you as an employer are found to have hired somebody and knowingly employed them without authorization, there's also civil penalties involved for that. And those fines range from $716 to $28,619. And the $28,000 is, kind of like multiple violations, the high end of the range. But, again, there's kind of civil liability relating to the form, and that runs to all employers. So you could have an all U.S. citizen workforce. If you didn't do your forms, you have compliance liability. So it's really important from from the outset, that all employers understand the role that they play in the I-9 process and the kind of management of our immigration system. And in thinking about the I-9 inspection, there are things that employers can be doing now in terms of best practices. One is to just understand and comply with the rules. Like if you walk away from this presentation, you think like, what's an I-9? Kind of like, if you like, go check the instructions. Kind of like understand what's going on. Think about it from a kind of a consistent practice for compliance. Make sure that the process does not include discrimination. It's another area of liability. Employers are not allowed to define or require the documents that employees present at the point of hire. A best practice and one takeaway from this is that when you're doing the I-9, always present the list of acceptable documents that are attached to the form to the employee, and make sure at the point of hire and also possible re-verification of their employment authorization that the employer is crystal clear that it will accept any choice of documentation that's valid for the I-9 that the employee wants to present. That's a very helpful starting point. As Sue will touch on, is complicated. Some people have work authorization that is not, kind of as apparent from the list as others. And it's important to kind of like run that to the ground. But if you're dialoguing with employee and you've started from the premise that here's the form, here's the list, I'll take anything, that's a very solid foundation to build the practice on as you're working through with employers. So, understand the form, kind of think about the fact that this has been in place for the last 40 years. Kind of you have an obligation to retain the forms for all of your current employees and for a period after the employment might terminate. So you might have forms on file that were created a long time ago. It's a good practice right now to think about, where are those old forms? Can I find them? How has our I-9 practice evolved over the years? I joke sometimes, that I can relate to the form also as kind of a old end of the millennial, born in the early 80s. But we've watched technology develop in our lifetime. So from the form, which started very much as a paper, form, which is still the case. It has evolved over the years in terms of employers stepping into and utilizing technology for how they completed it. So, employers, might have a whole range of ways that the form was completed. Well, they started in paper and then moved to an electronic I-9 vendor and, had maybe switched vendors over the years. So a good practice right now is just thinking like, all right, maybe I did the forms. Can I find them and can I get them if the government would ask to review them? And then kind of just planning for that possible, kind of possible inspection for the I-9s. The regulations allow the government to come and inspect your I-9s, so they tend not to be a big deal until they're a big deal if the government comes. And if you would have an I-9 notice of inspection, the government would come serve that notice or possibly a subpoena if they decided to kind of like elevate the request, and an employer has three days to turn over those forms. So kind of advanced planning at this point before you might receive that notice can help you be prepared if the government does come and ask to look at them. And also you can take kind of action to have remedial corrective kind of measures in place if you've realized when you review the forms that you did have a compliance issue at any point. So I have short time, so I'm talking fast. I'm trying to cover as much as I can. But I mean, I think another best practice for employers is to understand, kind of like where they might interact with the government in terms of immigration enforcement. And there is going to be, kind of a spectrum of possible immigration enforcement. There's a lot in the media and the news right now around know your rights. What do you do if ICE comes to your home, comes to your workplace? How can you prepare? And preparedness is really important, but it is essential when you're thinking about preparedness that, you as employers understand that there's a range of possible, kind of interactions with the immigration enforcement that could happen at your workplace. On one end of the spectrum is the scenario that we talked about, that the Immigration Customs Enforcement, Homeland Security investigators come and they drop off, a notice of inspection for the I-9s, and they say, we'll be back or we'll coordinate with you to receive those forms. That's, kind of that's one event that might happen. There's a possibility also of, the FDNS, which is a fraud detection unit, coming to a work site and making sure that a sponsored worker is doing kind of performing work in the way that was represented in a petition asking for that status. There's also on the, the other end of the more, kind of like enforcement and, kind of real-time concern end of the spectrum, the possibility that there might be a raid at the work site, or that the government may come to apprehend or arrest a particular individual. And that, doesn't run just to immigration. That could be for, a whole range of issues that the government might come, relating to an employer. But, there's, I think, a higher likelihood and at least a higher level of anxiety around possible immigration enforcement now. So, as employers are thinking about and preparing, not all situations are equal, and not all situations should be planned for or treated the same, because there's a, kind of a big gap in how, an employer would want to respond to an I-9 investigation as compared to the case that an ICE officer comes with a judicial warrant and says, I would like to see a particular person. But, I think that being said, there is some commonality in what employers can be doing now to think about how they would respond if immigration does come, in any capacity. And as I was thinking through this, I was myself, I came up with designate, document, de-escalate. And I was like, I mean, in terms of your takeaways, designate, kind of think about if you were to have the government come, who would you want the government to interact with? At the outset, by necessity, it's probably going to be your, kind of front of office, front of work site, front of house employee that would, kind of be the person that they would, meet at reception, or that would be the first in line. So, kind of thinking about how you would prepare that individual and provide information and, referrals for who they contact is a really important first step, so that there's not, kind of panic or any, interactions that could be handled differently if the officer comes and asks to speak with somebody. Thinking about designating, for a little bit further down that road, who do you want the receptionist to call? Who within the organization is going to be available and, ready to respond to this and help kind of like, guide and assess the circumstances. It might not be the same person for every type of investigation that gets us to document. It's important when the government comes to have instructions in the very beginning that information is developed about the officer's name, their badge information, and really why they're there. That helps to create a record of any type of enforcement, and really, kind of leads you into how you follow up, how you respond, and what information you develop on the front end. And the last piece of it is de-escalate. If you have somebody showing up with a, an I-9 inspection, you don't want to have the receptionist trained to, kind of yell, not without a warrant, and then everybody in the waiting room panic. I mean, there's this really, kind of the goal in enforcement will be to cooperate with the government, kind of as required, but to do it in a way that protects the privacy and interests of individuals and companies, that are involved by, kind of doing things like understanding that not all inspection, situations are treated equally, and, kind of developing the record and responding accordingly, because there are going to be variances in what the government might present or not that gives them authority or not to come into your workplace, to talk to your employees, to require you to produce, kind of people or records. And the response for employers should, correspond to why the government's there and what they have the legal authority to do. So I think, the other practical takeaway in thinking about this is, if you were to get the call, an early first question is, why are they here and what did they give you if you're off site for the receptionist? Did they give you a, inspection notice? Have they showed up with a subpoena? Is it a warrant? Is the warrant signed? Developing just at least as a threshold, kind of a plan, to handle these types of situations allows, I think, everybody to feel supported, from, kind of the company to the workers, to the people who will be getting the call, because it will be stressful and scary, for everybody, even in the best of circumstances, if, kind of the messaging is the government's here on site, even if there is absolutely nothing wrong with the organization, nothing to hide, and they say, I'd like to see your I-9s, and you say, like, I've been waiting for this moment, I've done such a good job for the last 40 years, like, here they are. There's still, going to be an element of stress attached to the messaging that the government is here. And on the de-escalation front, having, some advanced plan to make sure that that doesn't get messaged incorrectly to, ICE is at this work site, and it can create some panic. And, it is hard. There's a lot going on. There's a lot of anxiety. I'm going to flip this over to Barbara, in just a second, to think about, what role the employer can have, and, how employees can be supported, and thinking about messaging to help, navigate this, kind of like rapidly changing landscape. And I'll, kind of jump in if Barbara thinks that I missed anything, but otherwise, Barbara, do you want to kind of segue into the, kind of thoughts about supporting employees?
Sure. Thanks so much, Katie. I will say everyone is really lucky to have Katie here in Maine. She is a nationally recognized expert in this stuff. And so it's really wonderful to have her part of the community here. My name is Barbara Leen. I am a senior corporate counsel at Microsoft. I have to say that I am not speaking on behalf of Microsoft. I am speaking in my personal capacity. And, I'm here in part because, I live in Maine. I live and work in Maine. And I'm also on the board of ILAP. And so I've been working since I got here in some of the work that we do in the immigrant community here in Maine. So I'm going to talk a little bit about some best practices for employers, and then I'm going to segue a little bit to introduce Sue from ILAP. So I think, what Katie was saying, I think is really important to just remember in a very practical way, right? Whoever is at the front office, whoever it is that greets guests, they really do need to have a piece of paper next to them that says, if this person comes, here's what you do. They should have documented policies for what they need to do in order to de-escalate a situation. Employees, particularly if you employ really any or many immigrants, it's a scary time for them. There's a lot of uncertainty and there's a lot of things changing very quickly. And so I think good employee communication is important. If you work for an organization that sponsors employees for a visa or immigration benefits, it's really important to make sure that you have a clear policy about what you support and what you don't support, so that people understand as we go through challenging times what kind of support you can provide. If you get to a place where you're like, look, this is not something we can get involved in. So for example, if someone ICE comes in and they pick somebody up and they are subject to removal proceedings, it's important to make sure that if you can't support your employee in that journey, making sure that they know where they can go. And so, the immigration bar in Maine is pretty small, which is what comes to like how much of the work sort of does end up going to ILAP. And I know as a member of ILAP's board, I know they're going to be under tremendous strain over the next couple of years trying to respond to some of the changes in immigration here in this community, because of the types of workforce that we have here and the status that they're in. So I think for an employer trying to calm anxiety. So for example, yesterday there was an announcement, was it yesterday, the day before, Katie, that 2 days ago that immigrants need to register. And, people don't know what that means. And so they may go to their employer, particularly if you're a big employer. I think this is really germane for people who are, at schools. I know we have some University of Maine folks on the call, right? You're going to have students say, look, well, does this mean me? What do I do? If you're sponsoring H-1B employees, H-2A employees, what does this mean to me? And they'll go to their employer as someone who may be sponsoring them and say, you're in charge of my paperwork. What does this mean for me? So making sure that you're communicating good information and don't be afraid to say, hey, we don't know right now. We're looking into it and we will get back to you with what you need to know. And trying to project that level of calm, I think, is really, really important. Making sure that you have good counsel to give you the information that you need as an employer to make sure that you are complying with all of your obligations is really, really important. I think giving people resources to help them understand what their rights are so that you are not necessarily the spokesperson for that, but making sure that they have those resources available to them, I think is very critical. And that sort of leads me, I don't know, Katie, if you have anything else on the employment front, or I can introduce Sue.
No, that was incredible. That was very helpful. I will flag, I saw just a couple questions, so I'll just address very briefly the question about subcontractors, because I think this is really important. It comes up a lot. And the short answer is that employers are not liable for the employment authorization or verification of their subcontractors. That being said, in order to have that arm's length, kind of like lack of liability, it has to be a bona fide independent contractor relationship. And should there be a situation where, you are categorizing somebody as a contractor, and even if they are a bona fide contractor, you obtain any knowledge that they are not authorized to work, you as the employer will then be liable for unauthorized employment employment of that individual. So the short of it is that employers cannot misclassify individuals as contractors to avoid liability for having them work if they do not have work authorization. That's the flip side of the question. And I know no one on the panel, the questions were suggesting that they were doing that or that would be the case, but that's the way to think about it. So, bona fide contractor, no need to do the I-9, you're not required to. However, if you're just calling them a contractor and or that they do not have work authorization, liability will attach if you have them working for you.
So just to respond as well to a few things that are in the chat. Yes, just to be clear, we do mean the federal government here. The federal government does have jurisdiction over immigration matters. Now, that said, there has been a lot of talk about some agreements between states and the federal government for enforcement. Honestly, I think that's unlikely to happen here in Maine, but it will happen in other states. So all of this to say, like, the landscape is changing very rapidly. Things are happening with very little notice very quickly. And I know, like, Katie and I work together on, bar association stuff for immigration lawyers where we're, every day we're trying to come up with new practice advisories. And so when it comes to, things changing, I do recommend just having good advice. There isn't really a sample checklist that is publicly available, I think, right now on what employers can give to their staff, but you can work with your counsel to make sure that, you can come up with something like that. Try and make sure that they understand what they need to do. So there will also be, a good lawyer will help you understand what people need to do during home visits or site visits. Certainly, like if you're in a context where you're employing students, there's a lot of oversight for students, and that's for a good reason. And so there really isn't necessarily a reason to panic if someone shows up just to make sure that students are going to school. So I am going to introduce Sue here from ILAP. And again, I'll say, like, ILAP does bear an enormous amount of responsibility and takes it on willingly for the people of Maine and immigrants in Maine for both information and legal representation. It's been growing, but still the need is great. And so I want Sue to talk a little bit about some of the work that ILAP does and how you all can help support ILAP. Sue?
Thanks, Barbara. And also just want to echo Barbara's comments about Katie's, incredible experience, and also Barbara's included in that as well. They both have a lot of real national recognition. We have a small immigration bar in Maine, but they are really an incredible group. So yeah, thank you. As Barbara said, I can just give you a little bit of an overview of ILAP and the services that we provide, and then I can talk a little bit about some of the new executive orders and the impact they're having on immigrants in the community, and some of the things that you might want to make sure that ways that you can support your employees. So ILAP is, as Barbara mentioned, Maine's only immigration legal aid organization. We started about 30 years ago, first as a small pro bono project. And we've now grown. We're a statewide organization with about 30 staff and over 200 volunteers. We have full-time offices in Portland and Lewiston, and then we also have a regular presence through our Rural Maine project. The primary work that we do is providing direct immigration legal services to low-income immigrants, helping them gain work authorization and legal status. We focus on humanitarian forms of immigration, like asylum for those who fear being persecuted in their home countries, also helping young people who qualify for special immigrant juvenile status, as well as survivors of domestic violence and trafficking, and other immigrants who qualify for work authorization and legal status, like temporary protected status and deferred action for childhood arrivals. And we represent individuals in removal proceedings. We also have a growing project, a detention project, assisting individuals who've been detained by immigration and customs enforcement. And gaining legal status is really sort of the linchpin for somebody to integrate into the economy and the community. It's somebody's first step, and it also helps them obviously avoid deportation to a country where they may face harm and family separation. Immigration law, as both Katie and Barbara have, and Tarlan also expressed, it's a very complex area of law, and it's really difficult to navigate without a lawyer. Statistics show that someone's 5 times more likely to win their case in immigration court if they have a lawyer. But unlike in criminal law, where if you're low income, you have the right to have a government-funded attorney. For immigration, because it's considered civil, you don't have the right to a government-funded attorney. So somebody could be detained and deported to a country where they face harm, where they face permanent family separation without ever understanding their legal rights or their opportunity for legal status. And again, here in Maine, ILAP is the only place that people can turn to for free attorney legal assistance. We maintain about a 95% approval rate for cases that reach a final decision, and we're still turning hundreds of people away. So in addition to legal services, we also provide community education and outreach, and we also participate in systemic advocacy alongside with many of our partners in the Maine Immigrants' Rights Coalition, helping to change some of the laws and policies that impact immigrants in Maine. Each year we serve more than 4,000 clients from all 16 counties, and we have 200 pro bono attorneys who donate about 5,000 hours of their time each year, including both of the attorneys that you've seen here, Katie and Barbara. We have really great support from Maine's law firms providing pro bono assistance. So I could just talk a little bit about some of the recent immigration policy changes, and sort of to put it into context, the reason that you see immigration changing so rapidly is because there's an extraordinary amount of deference that's given to the president and the executive branch in terms of implementing policies and determining how they're going to be enforced. So instead of needing to wait for the process of something going through Congress to create a new law, or the public notice and comment period that are required for regulations, an executive order or a memo by an agency head can just be issued overnight. And that's why we see a lot of changes with administrations changing, like, all of the memos from the prior administration can be just very quickly overturned and new ones can be implemented. However, executive orders and executive actions still need to have statutory or constitutional authority. And we've seen President Trump issue many executive orders related to immigration. Many of them are being challenged in court, that they violate the law or the Constitution. And that sort of rapid issuance of new executive orders and the confusion about which ones are in effect and which aren't really creates a climate of chaos, fear, and confusion in Maine's immigrant communities and employers who have immigrants working for them. It's very unsettling for somebody navigating the immigration system to be it's hard for us as immigration lawyers to stay on top of all these changes, and for somebody who may not speak English and who's not a lawyer, trying to follow which executive orders are in effect and which ones apply to you is very, very complicated. And it just adds to this anxiety and fear that people are having. It also provides the opportunity for a lot of rumors to start getting around, even in particular whether a raid is occurring. Somebody sees one law enforcement officer in a building and they think there's a raid, and it gets out on social media, which causes additional fear and concern. And it also provides the opportunity, unfortunately, for some who are trying to exploit people. We have seen in recent years a real increase in the unauthorized practice of law, people going to people they think they can trust to help them get an application filed. And they're really taking advantage, taking money, and doing something that may cause harm. We also see people in organizations who are well-meaning and want to help, and they think that they can help by people filling out a form or answering a question, and it ends up causing problems that we see in our office, people coming to us and they've been ordered deported because they missed a hearing and they didn't, because somebody tried to help them. So some of we could talk for hours about a lot of the new executive orders, and they're changing by the hour, but a few that really impact Mainers. One is really just, as I was mentioning, that, they can just revoke all the executive orders of the last administration. And that's basically what happened when Trump went into office. A couple of key ones were one that was a prosecutorial discretion memo, where under the Biden administration, there was a focus on really trying to focus on those with serious criminal or national security concerns, focusing limited resources on deporting those individuals. And now under the Trump administration, really just anybody, regardless of their danger, is a target. Another was the rescission of the sensitive locations memo, which said that ICE would not approach people in churches and schools and courts and other similar places. There are challenges to that in other memo and other executive orders, but that is something that's been issued. Another is just an attempt to try to take away people who are in fragile immigration status, like parole and temporary protected status, trying to end those Temporary protected status is one that we are particularly concerned about at ILAP because we have hundreds and hundreds of clients, many who have been in temporary protected status for decades. And it is temporary protected status is basically when the government determines that because of a civil war or a natural disaster or something else in a certain country, they designate that country to have temporary protected status. So individuals who are citizens of those countries who can prove that they were in the country as of a certain date and meet other requirements can get temporary work authorization, typically for 18 months. When it's nearing the end of the temporary protected status period, the government will take a look at whether or not they can safely be returned. And often those the TPS period is extended. So for example, TPS for Honduras has been in effect since 1998. We have people who have been living here for decades. They have families. And it's really been a goal of the administration to end temporary protected status. We've seen that happen for Venezuela and Haiti. There are challenges there as well, but this is really going to be a real problem for many workers in Maine. Another executive order that was issued is the expansion of what's called expedited removal. And this is something that means that somebody who's not in legal status can be deported without a hearing. It was in the past only implemented against people who were in the first 2 weeks in the country and who were at the southern border, typically within 100 miles of the border. But now that can be implemented for anyone, anywhere in the country who can't prove that they've been in the US for at least 2 years. There is an exception for somebody who expresses a fear of persecution, but people don't often know that they can express that fear. At least at ILAP, we have not seen this implemented yet in Maine, but it is a significant concern because people may be inaccurately arrested and deported because they don't happen to have their documents with them. So we are really advising people if they have immigration applications in process or immigration status to make sure they're carrying those documents with them. Another, we're also seeing, expecting more executive orders, similar ones to continue, and also things in Congress. We saw the Lake and Riley bill that was passed recently, which has mandatory detention for people who are even charged with a crime like theft. There was also a very concerning movement in Congress. It sort of stalled, but it could sort of reenact at any point. And this was under Biden. There's a rule that was implemented that gives automatic extension of work authorization for people who are in the legal process of applying, for example, for asylum. Because of government backlogs, their cases have been delayed. They've applied for work authorization on time, but their work authorization application is delayed. It gives an automatic extension for 540 days because the government is very, very backlogged. And there is this sort of movement in Congress to rescind that rule. And we're hoping that that doesn't come up again, but if it does, it might be an opportunity for advocacy in the business community. So again, the impact of these executive orders and the sort of confusion about whether they're being implemented is really something that's causing a lot of fear. We're seeing that people are afraid to go to work in school. And just quickly, I realize I don't have a lot of time here, but just talk a little bit about some of the things that you can do to help support your employees. One is to make sure they understand their rights. On our website, we have a Know Your Rights information. There's also for employers, the National Immigration Law Center has a really great resource on what employers should do if immigration comes to your workforce. Making sure your employees are getting legal guidance and not going to somebody who's not a lawyer. Making sure they're following information from reputable sources and not just following rumors. And understanding that people are at different levels of risk. We have people who are in permanent legal status, people who are refugees and asylees. They're pretty safe unless they something happens like criminal interactions that might cause them to lose to put into deportation proceedings. And then we have people who are in very fragile status who are either out of status, even though they may qualify for status, or they may have a final removal order. Those are the most at-risk people. But then there's a large group of sort of fragile people who have a pending application and they have work permits based on that. They may have parole or temporary protected status. And this is, probably more of your employees than you may realize. And this is where a lot of advocacy will need to be coming into effect to try to make sure that our congressional delegation and the government authorities understand the impact this would have in Maine. So other things you can do is connect your employees to ILAP. We do have limited capacity, but you can go onto our website, ilapmaine.org. to sign up for an intake appointment to have a legal consultation. We also have walk-in hours every month in Portland and Lewiston, and that information's on our website. We also are sending out regular community advisories on the new executive orders and the impact in our communities. You can go on our website to sign up for those and our monthly Golden Door. And then also, as Michael will talk about, you can engage in advocacy when there are things, laws, and executive orders that are going to be impacting your ability to keep your employees employed. It's really an opportunity for the business community to engage in advocacy. And with that, I will turn things over to Michael.
Susan and Ella, for all your work, and thanks to the Maine Chamber for having us on. Thank you, Patrick. My name is Michael Deheeger. I'm going to pull up some visual aids, and you might hear my kids arguing about Moana 2 in the background. I'm in Arizona, so we haven't done drop-off yet. Let me just find here we go. All right, can folks see? So I'll go ahead. I am very pleased to be on here as a Colby College grad, class of 07. Maine has a very special place in my heart. And I'm campaign director with the American Business Immigration Coalition. We're a bipartisan group of employers across 19 states. Folks may be familiar with the Maine Business Immigration Coalition. MBIC became part of ABIC a few years ago. Our work in Maine has been led by David Barber of Barber Foods for quite some time. And basically, we are supportive of immigration reforms that secure the border while expanding pathways for immigrants into the workforce and while offering stability to immigrants in our workforce that our economy relies on, that have been working and paying taxes, are valued community members, valued employees and employers in many cases as well. So our leadership is bipartisan, business leaders, folks all across the political spectrum. And we believe really strongly in bipartisan engagement. You need both sides, both wings to fly the plane. So not by accident. We have a picture of recent meeting with Susan Collins up there in the left corner. But all across the country, we're engaging with folks on both sides that want to see something move forward that meets the economic needs and the humanitarian need that a lot of folks that everyone on this call works with deserve. Without harping on this, I think that folks are clear about the urgency of addressing this. I mean, the workforce crisis has been bad for a while across industries, and we've got folks in ag, construction, hospitality, healthcare. Everyone's singing from the same songbook on this. And as folks on this panel have already covered, if there are additional destabilizing policy decisions, we're very concerned about the economic impacts of this, as well as the human impact of this. And Stephen Moore here from the Heritage Foundation speaking a bit to this recently. But with these legal work permit programs being potentially under threat, or folks being removed from the workforce, that's going to have very direct consequences in terms of prices, in terms of operations being able to continue all over the country. I feel like this has been covered, so I'm not going to spend more time sort of in what the current challenges are. What I will say is that we think there's going to be a lot of value, and employers have a critical voice in engaging with this administration and with Congress. We do think that if there is a constituency of employers across different sectors, we have an opportunity to move forward constructive policies in partnership with the Trump administration and with this Congress. And President Trump, back in the fall, spoke to the urgency of solutions for dreamers in particular. So at the moment, of course, there are policies that we've seen that we have concerns about, and we are engaging with the administration, with Congress about that. And we hope that they will be receptive to working with employers on constructive solutions. And I want to speak a little bit to what employers are doing on that currently. So we think it's important to get out there. Folks might remember Dana Connors, former CEO of Patrick's predecessor up there. That was a couple of years ago now. But you can see some of our members around the country speaking to the ag workforce. There on the right is Tom Swazi, a Democrat from Long Island last year. The Comité de Cien on the lower left is a recent launch of our Latino Business Leaders Council, Massey Villarreal at the mic there chaired the Hispanic Gala at the inauguration. And just folks on here from a very, very broad range of industries. That one in the middle is from the South Dakota State Fair. And our folks are speaking to engage the public and really, connect the dots for the American public and for our elected officials about what it means when they don't have the workers that they need. It means that venerated institutions are under threat. We had Eli's Cheesecake from Chicago. Folks might be familiar on a presser recently. We're already seeing eggs, sell out also with the bird flu stuff go on. That's only going to get worse if employees are removed from the workforce. And so what we're doing is offering places where employers can connect with folks in their sectors or across different sectors to work together and have just a peer group and a support network to engage elected officials together. You all in Maine are very fortunate that you have really, I think in your delegation, leaders in bipartisan partnership. Senator Collins and Senator King have been absolutely very, very serious about addressing the concerns of employers and working across the aisle on this. And it's helpful for them to know that employers have their back. So I think, folks who want to get involved, your first stop should be the Maine Chamber, and we also are here to support. And some of us are going to be in DC March 25th and 26th to speak with Congress directly, and we can circulate information on that later on. So I'll just close with saying that as employers, this does come down to policy. You all have a critical voice, and we think it's going to really take folks from both sides of the aisle to move things forward. Appreciate the opportunity to be here.
Well, thank you, Michael. I hope the listeners understand that their voice matters in these topics, both for trying to create a pragmatic immigration system. We certainly have been encouraged by the congressional delegation's role in this and think that there can be leadership in Congress to really create a clear pathway for addressing our border, but integrating immigrants into our workforce. I do see a number of questions in the chat box that we won't be able to address all of them. But I did just quickly want to see if Katie wanted to address the E-Verify question. There's a question from Vinny Caliendo about E-Verify. That may be preferred. Can you comment on that, Katie?
Yeah, so E-Verify has kind of been in place for a while, and right now it is a voluntary, generally, complement to the Form I-9. It's an electronic component that is entered into after you complete the I-9, and it checks government databases relating to Social Security Administration, DHS, and employment authorization. It's mandatory in some states. It's mandatory for some federal contractors. It's mandatory if you want certain benefits. But right now it's kind of a companion, and it does not replace, and it does not, kind of zero out. It complements the Form I-9. Will E-Verify become mandatory on the national level? We don't know. That's been in the mix for a while. I will say that there was just an executive order that directed that there's an end to taxpayer subsidization of open borders. That was the title. And it includes a directive to enhance eligibility systems. So, I think that the question of what our verification practice will look like over the next several years will be an open one. I do think that there probably will be developments and changes. It's something that employers should track and they should understand. And it is really confusing. Everybody has to do the I-9. What's E-Verify? It's a supplemental attachment to it. Is that the same as an electronic I-9 system? No, that's when you create and retain your form electronically. Is that the same as virtual I-9 that came out of COVID when you're in E-Verify, but you review your documents on screen? No, that's also different. Is it the same as E-Verify Plus? No, E-Verify Plus is a new program that the government's rolling out. And it, kind of like it shifts around the E-Verify system a little bit, kind of making the employer do stuff early. And I will just say in closing, kind of like keep a close eye on the communications and just, kind of track it, because the information coming out of the government right now around E-Verify Plus, referencing it as an electronic I-9 system and the directions from it is a little bit confusing for employers. So I think the short of it is that, right now, kind of like the past is the I-9, that's still the requirement. Will it change? Possibly. It's important to keep on top of it. But, if you're not sure, kind of double check to see what you're working under, because it's very easy to get those terms mixed up. And all it takes is, one misunderstanding to have a 100% non-compliance rate for your I-9s, because you started to, kind of like think E-Verify was one thing and it wasn't. So, it's kind of a long answer, but I think just there's more to come. I think that's the short of it.
And we do have to conclude on a prep call for this. I thought one very relevant piece of advice is, if you want to support employees and you're the employer, what do you recommend for that relationship in terms of direct involvement or advice for supporting employees that may have been with you for a long time? Katie, if you want to take that.
Sure. I mean, I think that the short of it is that it's no one size fits all. And I think one takeaway is that, as Sue pointed out, kind of a lot of the people who are feeling the most vulnerable, they did clean I-9s and they have work authorization. They're worried that their temporary protected status got shortened and they might have to leave their U.S. citizen kids behind. So I think, kind of just having a solid foundation for a lot of this, having fair practices, as Barbara said, clear policies, thinking about, this from a non-discriminatory standpoint, and kind of just being thoughtful in your communications, and kind of understanding what your employer is able to do and what they can, and communicating it clearly makes sense. I think it would be easy from the front end for an employer to say, like, we've got your back, like we'll do whatever, and then if they can't deliver on it, that's harder. So I think, from the employer standpoint, just being really mindful around what their industry is, what their organization is, what their mix of employees is, and creating and planning from a practical standpoint will be the best bet, because the harsh reality is sometimes there's not a whole lot you can do. I think sending them in the right direction to ILAP is an exceptionally good first start, but kind of just being mindful and keeping these front of mind, and understanding that kind of there's dignity to every employee no matter what their status is, and kind of proceed accordingly.
And Patrick, I'll add to that. I think if you are sponsoring your employee, so you are the basis for their visa for being in the United States, like, you may have greater obligations when it comes to helping them understand the papers that they need to have. If somebody questions their status, if something's wrong with their paperwork, it really is on you as the petitioner to help them understand what they need to do and navigate them through some of those issues. But at the same time, you may also need to tell them that if they engage in a crime, you're not going to assist them, in which case it's a really good idea to just give them some resources and make it clear what it is that you can do and what you can't do. I mean, if someone picks them up, if ICE picks them up because they think that their H-1B isn't valid anymore, you are involved, right? Because you're sponsoring that H-1B. So there's not one size fits all. You need to look, at your workforce and understand that on every level, some of these changes could be impacting them.
Well, I do want to thank all of the speakers today. It is a dynamic, fast-moving area that's complicated to begin with. I do want to reinforce our appreciation of Pierce Atwood and Native Maine Produce and Specialty Foods for sponsoring today's event. The Maine Chamber looks forward to continuing this education of a critical element of the new administration and impacts to our labor force in Maine. With that, we'll conclude the webinar. And again, thank you for your partnership in addressing immigration and working as an employer for best practices. Thank you.